Good afternoon, everyone. Welcome to the Law Tech Talk. I am Professor Anjan, the co-director of the Law Tech Center. Today, we are very pleased and honored to have a German scholar joining us, delivering our Law Tech Talk. So I would like to introduce Dr. Dennis-Kenji Kipker from the University of Bremen from Germany. Is a beautiful little town in Germany, and for those who are familiar with fairy tales of Germany, then you will know the story of the Bremen music cantors. Dennis is the scientific director of the Institute for Information Health and Medical Law at the University of Bremen. He has his own IT privacy and compliance firm called Tafel. So he is really truly interdisciplinary scholar in technology and law. And among his many accomplishments and achievements, I would like to highlight the last one, that is, he is the editor-in-chief of the International Journal of International Cybersecurity Review. And this is a journal that is in English. So for those who are interested to submit articles to that one or to read that journal, I would encourage you to do so. And today, Dennis will share with us this important topic and the debate of cybersecurity. He will cover the issues in Germany, Europe, and also give a comparison with the situation in China. So for those of you who would like to raise any questions, you can do that through the Q&A of the Zoom feature. And Dennis will speak for 45 minutes, leaving about 15 minutes for our discussion. So I will pass the time to Dennis.
Thank you very much, Anne, for your introduction and the possibility to speak here today virtually. And I'm very happy to do so. And I will now share my screen to show you the presentation that I have prepared for this session. So today's talk will be about international cybersecurity regulation, new path and new problems. Anne already introduced me. I'm Dennis Kipker. I'm working as Research Managing Director at the Institute of Informational Law at the University of Bremen. And I'm also Executive Director of the Certevo Corporation. And what we'll be doing today in this little presentation, New Path and New Problems of International Regulation of Cybersecurity, are 4 topics that I will deal with today. So firstly, we will have a look onto the technical and political background of cybersecurity regulation. That means, why is cybersecurity regulation triggered, by which technological developments it is triggered, and what will be the results from a legal perspective based on that. Secondly, we will talk about cybersecurity as an interdisciplinary challenge, because compared to privacy and data protection law, cybersecurity is much more has much more technological parts in it, much more technological perspectives in it. And this is why it is interesting for us to get to know also the regulatory borders when it comes to cybersecurity regulation. As Anne already announced it, we will also have a short comparative part here with regard to the Chinese cybersecurity law. And finally, we will have a short conclusion and a wrap up of the whole presentation that I did today. And afterwards, we'll have some time for questions and answers. But let us directly start with the political and technical background of cybersecurity regulation. And cybersecurity regulation is, generally speaking, a relatively new topic. So the first real cybersecurity incident, which became also of global interest, was the Stuxnet worm, which occurred in 2010. So this was a computer worm, which supposedly has been created by the governments of Israel or the United States. And the task of this worm was to infiltrate the Iranian centrifuges for uranium enrichment in Natanz. So it was a digital military operation to destroy these centrifuges. And the idea behind behind this Stuxnet worm was that it varied the rotational speed of the centrifuges, and because of this variation of speeds, the centrifuges shut down. And as you already can see in the graphic here, you can see that the number of inoperative centrifuges increased since the attack, which started in February 2029. So you can see that there are many more of these uranium centrifuges for uranium enrichment, which went out of operation due to this computer worm. And it is said that this tactical operation, this digital operation, had been a similar effect onto the uranium enrichment plant as when a normal military operation would have been conducted. And this shows to us the power of attacking IT systems, the power of having virtual attacks on IT systems. And the second thing I want to talk to you today is a case that occurred in January 2019, when the German parliament has been attacked by a very young hacker coming from Germany. And firstly, it was assumed that the attack was based on political issues. The idea behind this attack was, as you can see on the left-hand side of the slide, that the hacker named God, he had a Twitter account, and every day as an advent calendar, he announced or he made sensitive information of German politicians, of the federal parliament, public. And you can see it here that several members of the German parliament had been affected by this. And there was a large debate in Germany because politicians said we need more protection, we need more and strict laws for cybersecurity protection of people that are more prominent than other people. In fact, no law had been created based on this attack, but it shows us that everyone could be the target of a cyber attack. And recently, very recently, in September this year, in the COVID-19 times, we also had an attack onto a big German university hospital, which is situated in Düsseldorf. And this attack resulted a cyber attack of a ransomware software was used. That means all the data, all the patient data as well, was encrypted in the hospital. And the result of this was that treatments, especially initial treatments, could not be conducted anymore. And the result from this was that we had a death of a woman, which was linked to this ransomware attack of this German hospital. And with that, there are questions which arise concerning state-of-the-art of technology, legal compliance of the hospital with regard to cybersecurity, possibly contractual claims, as well as tort law claims with regard to the death of the German woman as a result coming from the cyber attack. And this also shows us that the regulation and protection of so-called critical infrastructures against cyber attacks is of higher importance than ever from a political perspective. But it is not only about protection of against privacy breaches. It's not only about the protection against cyber attacks of critical infrastructure. This is much more when we talk about cybersecurity threats, because today, with more and more network devices, we also have a multilateral threat situation. And on this slide, you can see some things that I wanted to tell you, which I think are important. So in the middle of the slide, this is an article in the Cybersecurity Law Review, which deals with global disinformation campaigns and its legal challenges. It had been written by Tomoko Nagasako. She is a Japanese researcher coming from Tokyo. And this is, in my opinion, a very interesting article, because I think today it's not about finding the right information or finding any kind of information in the World Wide Web. The question is about, do we find correct information? How is it possible for us to distinguish between disinformation, fake news, and correct information that we find there. So this, in my opinion, will be one of the important things to regulate and to deal with in the upcoming next decade. Another point here is taken out from the Symantec Internet Security Threat Reports. You might have heard of Symantec. It's a US American security firm, and they produce software for companies as well as for consumers when it comes to security and protection of IT systems. And they said in their security reports dating on 2016 and 2017 that on one hand, attackers, cyber attackers, attack large and small businesses the same way. So that means when there's anything to get, when there's anything that will be able to make, when there's any chance to make profit, the attackers will attack these companies. And there are many possibilities to attack these companies, because in the underground marketplaces, we can find nearly everything to buy. Ransomware toolkits for encrypting computer systems. We can buy DDoS short durations. DDoS means distributed denial of service attacks. For example, when you want that a certain website is not online anymore, you can buy documents, Android banking Trojans, credit card data, as well as cloud service accounts and data coming out of cloud service accounts. And there is also another point which I like to mention when it comes to this multilateral threat situation. It is the problem that we have also more and more state actors and very well equipped state actors conducting cyber attacks. One big case, which is already 7 years ago, these had been the Snowden revelations, the so-called Summer of Snowden in 2013, when he revealed that the US American government has been conducting a large surveillance program, which is called PRISM, and that many US services, which are quite well known, you see it here on this PowerPoint presentation, such as Gmail, Facebook, Yahoo, Google, and even Apple or YouTube, had some links with the PRISM program. And that shows to us that this multilateral threat situation also we come to the conclusion with this multilateral threat situation that we also need a complex regulatory framework for the protections of states, for the protection of companies, as well as for the protections of the consumer and citizens against cyber attacks. And when it comes to the regulation of cybersecurity, we always have to take into account the technical and organizational part of it, because the law is somewhat limited. I mentioned this in the beginning. And when the politicians and when the parliaments want to create new laws, they always have to take into account these technical and organization issues. And the problem is, for many companies today, especially small and medium-sized enterprises, SMEs, that it is very difficult for them to be able to implement these legal rules that will be or that are being created by the legislators. One example which you can see here is this cartoon here. There's this woman, maybe she's in charge for cybersecurity or for IT compliance, and she's talking about to the management board about disaster recovery with regard to cybersecurity issues. And it's pretty clear that there's no budget, that there's no idea on how to realize cybersecurity. And this is a problem that many small and medium-sized enterprises are dealing with, because they do not have the budgets, they do not have the personnel which is in charge for that. And cybersecurity is very complex and can, for this reason, not be a part of everyday ordinary management procedures. And as you can see it here, IT security compliance is complex and multi-layered, because business continuity management has to be implemented. Information security management, the so-called ISMS, is a basis, legal and technical basis for cybersecurity compliance. And you also have to implement a plan to check act circle. That means, well, cybersecurity is a thing that has to be conducted regularly, because technology changes, and it is necessary for you as a company, and of course, for authorities as well and private people to identify so-called assets. That means protection goals. So which are the most protection-worthy fields of data in your organization or in your company. And when it comes to the regulation of cybersecurity issues, there are several questions which are to raise. So firstly, what is the right way to tackle this challenge? So do we need a reactive or a preventive legal regulation of cybersecurity? And what could be the primary legal source for IT security law? Can it be found in the civil law and the punitive law, or is it more a thing of the public law? And this, of course, are the issues that national as well as international cybersecurity strategies will have to address and prior to create any cybersecurity regulation. And this is also a thing that is being done by the national legislators as well as by the European legislators. And this is why I will present to you in the next minutes the key parts and main issues of the idea behind the German as well as the European cybersecurity strategy. So the first German cybersecurity strategy has been announced in the year 2005. On this slide, you see the Chancellor, the German Chancellor Angela Merkel, and she's of course also in charge of the protection of cyber attacks on German infrastructure. And the newest cybersecurity strategy of Germany has been announced in the end of 2016. And currently, the German government and the German governmental authorities are working on a new cybersecurity strategy, which might be finished in 2021, mid-2021. But as you can see it here from the statement of Angela Merkel, she said that the cybersecurity situation and threat situation has evolved and it is quite difficult to deal with. So she said, as a quote here, today, we have a huge amount of possibilities to paralyze infrastructure from cyber attacks, and it is very, very difficult. That means we have more and more connected devices. Businesses are more relying than ever on the internet, the World Wide Web. And she said that the government of Germany has updated its cybersecurity strategy, and we are very happy to work with localities on this. And the question which arises from that, what are the main parts, what are the main ideas because of this German cybersecurity strategy? Because the German cybersecurity strategy is a blueprint for German laws to be created for cybersecurity and infrastructure protection. This is why I have on the next slide just written down the main ideas and the main bullet points here of this German cybersecurity strategy as of 2016. So the first idea in Germany was that critical infrastructures should be protected, because critical infrastructures can be seen as a backbone of the whole economy, of the whole society. And for this reason, the first IT security law of Germany, dating on 2015, and there was a definition of critical infrastructures and critical infrastructure sectors, because they have a high importance for all economic areas. And there's a goal in Germany to conduct a public-private partnership when it comes to critical infrastructure protection. That means that critical infrastructure operators as well as the state authorities should work together on an equal level. Of course, this is not possible every time, because we have a subordination system between authorities and private operated critical infrastructure operators, but it works pretty good at that moment. And the second idea was that cybersecurity is, of course, not only about critical infrastructure protection, it's also about securing IT systems generally in Germany. So that means we have to protect citizens, as well as the aforementioned small and medium-sized businesses who do not have the capacities to conduct cybersecurity activities on their own. Third point here, strengthening IT security in the public administration. This is also an important point because in Germany, public administration is not a part of the critical information infrastructures, because it was said that the public administration, that means authorities, governmental agencies, they have the task to protect the economy and the citizens against cyber attack, and they, as a protecting actor, cannot be seen for this reason as a critical information infrastructure themselves. But of course, there must also be duties for public administrations and operators of public institutions to be conform with state of the art when it comes to cybersecurity protection. And this is why there are also several legal regulations based on this cybersecurity strategy that deal with cybersecurity in the field of public administration. And a National Cyber Response Center has been introduced in the last years in Germany. And the National Cybersecurity Response Center is an entity which is put together of several different authorities in the field of cybersecurity. And there's an information and threat intelligence exchange, and there's also an exchange of information when it comes to technical and organizational strategy to fight against cybercrime and to fight against any occurring cyber attacks, or when to conduct preventative measures against cyber attacks. So the National Cybersecurity Response Center is a very important aspect of the German cybersecurity that we currently have here. I mentioned it a few slides ago. So when we raise the question about cybersecurity regulation, this question also deals with an idea on which level to do the cybersecurity regulation. So that means, is it a part of the public law? Is it a part of the punitive law? Or is it part of the civil law? And the strategy is trying to address these issues in all different levels of regulation, so it can be seen as a multi-layered approach here. And this also means that there should be a stronger possibility for effective crime control in cyberspace. So that means strengthening capabilities of law enforcement agency, having new punitive laws with a special regard to information security. Then it is said, because cybersecurity issues do not stop at the borders, that a worldwide and global approach is needed. And this is why the threat information exchange is also linked to international corporations such as United Nations, OSCE, Council of Europe, OECD, and NATO. And the last two points here of this German cybersecurity strategy generally address the more technological sphere. So it's also about digital sovereignty, what we are talking about. So to intensify the research in Germany and Europe on IT security and critical infrastructure protection, that means creating also own devices, creating own microprocessors, and not to buy these devices from third countries. And currently we are in Germany in the legal debate about a second IT security law, which has much to do with the topic of digital sovereignty. Also, if to the question if 5G components of Huawei can be used in the so-called critical infrastructure environment. So there are many problems ongoing with that, and currently there is no legal and political solution found yet for this, to this problem. And the last point here, tools to respond to cyber attacks. So it just says if the state wants to be fully prepared for cyber attacks, a coordinated and comprehensive set of tools to respond to these cyber attacks must be created. And this is why we have federal authorities that are creating technical tools to fight against cybercrime and cyber attacks. To come to a European level, the newest version of the European cybersecurity strategy dates on 2017. And it was announced during the yearly State of the Union address by the former President Jean-Claude Juncker. And he had some remarks about cybersecurity issues, and it is quite interesting because the European Union has, from a political point of view, quite a different approach when it comes to cybersecurity regulation. You can see it here that he says that Europeans place great trust in digital technologies. They open up new opportunities for citizens to connect, facilitate the dissemination of information and form the backbone of Europe's economy. So it's more about an economical decision here when it comes to cybersecurity than the idea of protecting the society as a whole that we had in Germany with the cybersecurity strategy. And he also says that last year, so that means in 2016, there were more than 4,000 ransomware attacks per day in the European Union. And 80% of European companies experience at least one cybersecurity incident. So I guess this is a lot. And this is why the European Union said we need to do something, because data flows do not stop at the borders. This is also why we have a European Data Protection Regulation, GDPR. And this is why the European Union said we must facilitate the trade, we must strengthen the digital interior market, and this can only be done when we have a uniform cybersecurity strategy and uniform European cybersecurity regulation. And ENISA, which is the authority that is in charge in the European Union for cybersecurity issues, the European Network Information Security Agency, received more powers by legislative decisions of the European parliaments. And there's also a so-called European certification scheme for cybersecurity to be created, and the ENISA is here in charge as well. When it comes to concrete regulation of cybersecurity, it is to say that in Germany, in the European Union, and as in many other states, when we take a comparative legal approach, that there are many, many legal laws and legal provisions. And the problem is that all these different provisions, some of them are only applicable in some sectors, some are mandatory or not. Some use general terms where cybersecurity can be read into, make it very difficult for lawyers and as well as for technicians to understand cybersecurity compliance. And this table, which you can see here, is a table that we have created from our research in the last 2 years. And it shows us that there are more than 2,100 cybersecurity regulations, legal regulations, not technical regulations such as norms and standards, only in Germany and the European Union. So we have no kind of codification. And this is a very difficult situation for cybersecurity compliance. And there's also the fact that international regulators of nearly all states that I know, industrial states, are currently creating their own cybersecurity laws. So we are in a situation where more and more laws are created. They're difficult to understand, and this makes cybersecurity compliance to a problem. And I just have, because we do not have so much time today, listed on this slide the most important regulations, recent regulations of cybersecurity and privacy in the widest sense that can be found in Germany and the European Union. So the first one, which I like to mention, is the EU Network Information Security Directive, the NIS directive, which was introduced in 2016. And the NIS directive deals with so-called critical infrastructure protection, as well as the protection of digital service providers such as online marketplaces, online search engines, and cloud computing providers. Then we have GDPR, which I guess you know already. GDPR also contains special rules for technical and organizational data security, especially Article 32. Then we have the EU Cybersecurity Regulation, which is synonymously called the Cybersecurity Act, that will introduce the cybersecurity certification system in the European Union. Then we have a draft regulation for a new center of excellence on cybersecurity, and this will be some kind of research authority. This is still a draft version. I assume it will pass the parliament in 2021, and it might be situated in Brussels. Then on the German layer of regulation, the national layer, you can see the aforementioned German IT security law of 2015. There had been two concretizing sub-legal decrees, the BSI Kritis Verordnung in Germany, and they define numbers, so thresholds, when a certain entity, for example, in the energy sector, the telecommunications sector, can be considered as a critical infrastructure. We have the draft version of the second IT security law of Germany. The latest draft version of this law had been issued in this month, so just 1 week ago. It was on Friday last week. And also, as I mentioned before, this law deals more with consumer protection as well as digital sovereignty. And digital sovereignty is a topic which is quite hot right now in the European Union by politicians and legislators. And I assume that there will be some laws following dealing only with the protection of digital sovereignty in the European Union. And another law which I would like to mention is the so-called Second Data Protection Adaptation and Implementation Act of the European Union General Data Protection Regulation, because even though we have a EU GDPR, it's just a basic law for data protection. And in some cases, the member states of the European Union are also allowed to still create their own respective privacy regulation. And this has also been done by Germany in 2017. This is quite a long law, so it has about 150 articles or single laws which are being changed by this law, and it contains about 500 pages of legal texts. And to get an overview of all these different regulations, we have created with our research at the University of Bremen a so-called Cybersecurity Navigator. You can find it online under the domain cybersecuritynavigator.de. Unfortunately, it's in German, but the European legislative acts are in English. And you can just choose several branches, several different infrastructure sectors. And this tool has listed in its database nearly, I would say, 99% of all relevant cybersecurity regulation in the European Union, as well as in Germany. And this tool will list when you type in a certain keyword or when you select the infrastructure sector, this tool will list all the relevant provisions on cybersecurity regulation from a legal perspective, as well as from a technical perspective, because the technical norms and standards are also included into this research. When you assume that you're an IT security compliance officer in your company, then you have seen that it is already difficult to find out which are the concrete laws which are applicable to you. The second step would be the interpretation of laws. And there we come to another very important problem, because I mentioned this also in the beginning of this presentation. Cybersecurity regulation is more an interdisciplinary challenge than privacy regulation. And this is important because the law sets several security requirements, and we as lawyers will have the task to interpret these security requirements. And the question is, how can we do that? Because we are not technicians. And the idea behind cybersecurity and effective cybersecurity is that security is a process, not a product. This is a remark that Bruce Schneier, who is a very well-known US-American IT security expert, has made a few years ago. And he says that cybersecurity is nothing that you can buy and just put into your computer system and then you do nothing for several years. It is important to mention that the technological situation, the threat situation changes from month to month. So cybersecurity compliance means that you will always have to take a look onto the cybersecurity market, onto the threat situation, and based on that, make your decision on how to be compliant and how it is possible for you to fight against any cybersecurity threats. And this is also a problem when it comes to the interpretation of laws. This is an article that I have taken out of the EU Network Information Security Directive, and it is about security requirements and incident notification, two key parts of the EU Cybersecurity Directive. So it is said that member states shall ensure that operators of essential services take appropriate and proportionate technical organizational measures to manage the risks pose to the security of network information systems which they use in their operations. Having regard to the state of the art, those measures shall ensure a level of security of network information systems appropriate to the risk posed. And then a second paragraph says, member states shall ensure that operators of essential services take appropriate measures to prevent and minimize the impact of incidents affecting the security of the network and information systems used for the provision of such essential services, with a view to ensuring the continuity of these services. So there are several questions which arise for us as lawyers from this article. So what are appropriate and proportionate technical and organizational measures? How can the state of the art, which is mentioned 2 times, how can this be legally defined? What is a level of security of network information systems appropriate to the risk posed? And what are appropriate measures that should be taken by the operators of essential services? What does it mean for them? And what does even security as a term mean? Because we don't have any legal definition of security. We also have the term safety. So what is the difference between safety and security? How can we be sure that we make a correct interpretation of laws when it comes to these cybersecurity measures that have to be taken and when they will not be taken? So when companies, critical infrastructure operators are not compliant, then there will be administrative fines, relatively high administrative fines as well. When it comes to the interpretation of laws, we can use in the European law the recitals of a certain legal act. Here, the recitals of the EU Network Information Security Directive. But these recitals do not give so much information about these technical issues as well. So they mostly say the same things that we have read in the law. So member states shall ensure that operators of essential services take appropriate and proportionate technical and organizational measures, and so on, having regard to the state of the art. Again, this legal term, this undefined legal term, those measures shall ensure a level of security of network information system, again, appropriate to the risk posed. So nearly the same formulation that we also can find in Article 14. Some more information is being given by Recital 53 because it is said to avoid imposing a disproportionate financial and administrative burden on operators of essential services and the so-called digital service providers. The requirements should be proportionate to the risk presented by the network information system concerned, taking into account the state of the art of such measures. In the case of digital service providers, those requirements should not apply to micro and small enterprises. So Recital 53 says, when it comes to cybersecurity, not every measure has to be taken. There should always be a weighing of risks, a weighing of the financial costs of a certain measure. So this gives us some more information about the interpretation of the undefined legal term state of the art. And IT security is, I mentioned it in general, an interdisciplinary challenge. And this interdisciplinary challenge is not only addressed by the EU Network Information Security Directive. You can find these undefined legal terms, which can be generally seen as openly formulated legal terms, which are normally not concretized by the law itself, but on the basis of further definitions, which may also be a part of an extra legal framework. They can be found in several other European laws. So we have this Article 14 of the Network Information Security Directive. We can find the same term in Article 32, GDPR, when this law refers to the state of the art of technology for the technical and organizational protection of privacy. And in Article 4 of the still currently existing e-privacy directive, which is quite outdated because it came into force in 2002. But there's also the term state of the art and the cost of their implementation. So we have several hints on how to interpret these legal issues, but it's not completely clear. And this is the thing or an aspect where the technical standardization becomes interest. So the idea behind indefinite legal terms is that there are some advantages, of course. Advantages means the technology changes that fast, in such a fast way that the national legislator or any European legislator would not be able to implement technical questions directly into the laws. The disadvantages, of course, are legal uncertainty, legal uncertainties for the companies which are in charge for implementing these laws. And currently, there are technical norms and standards that are being used for the interpretation of these undefined legal terms that can be used in the cybersecurity law. And the most important standards with regard to that is the ISO IEC 27000X standard. It's about the implementation of an information security management system. And as you can see that data flows do not stop at the borders, cybersecurity incidents do not stop at the borders, it is important to find a global approach. And you see here on this map, the member states of the International Organization for Standardization, which also has created the ISO IEC 27000X standards. And you see that most of the countries in the world are definitely member states of this ISO organization, which makes it easier for us to have some kind of global interpretation of national laws in the field of data security as well as cybersecurity. And when we put all the information together, we can well see everything in such a picture as it is well here on this slide. You have on one hand the operators, especially of critical infrastructures, of digital service providers, and then you have the national authorities for cybersecurity. And in the case of the European Union, both of them have to cooperate, and the national authorities cooperate with the ENISA as well, which you can see here on the right-hand side, this little bubble. And the operators are in charge to implement an information security management system based on the European law, as well as, for example, on the German law, which has to be compliant with the European law, of course. And they have to implement this ISMS, which can be based on the ISO IEC 27000X standard. They have to maintain a contact point to the cybersecurity authorities, to the national ones. And if there is any cybersecurity incident which occurs or any threat relevant information, it has to be changed with the national authorities. The national authority will again share this threat information with the European authority, and the European authority will give this threat information to all authorities of the member states of the European Union. And then this information will flow back to the operators when it has been collected by in the German case, by the Federal Information Security Office. It will go back to the operators. They will evaluate this information as well and put it into their own information security management system. And this is why they will be able to maintain the state of the art of technology when it comes to the implementation of laws. And this is why they also will be able to conduct a plan to check act cycles as a part of the business continuity management system. So this is a situation that you have in Europe when it comes to cybersecurity regulation, the current legal situation. Finally, I would also like to come to a short comparative approach here with regard to the Chinese cybersecurity law. And it is to say that the Chinese cybersecurity law attracted a lot of, well, there are many people interested, many companies interested, politicians interested in this Chinese cybersecurity law, because the implications of this Chinese regulations are quite high for German and European companies, as well as other international companies. And I will show you why. So firstly, it is to say that the Chinese cybersecurity law has compared to the European regulation of privacy and data security, a double focus. So why we in the European Union have two different laws mostly, and we distinguish clearly between cybersecurity and data protection. The Chinese cybersecurity law tries to put both together as a holistic approach. Maybe this situation will change because we have a cryptography law in China, we have the draft version of the new privacy law and data security law, but the Chinese cybersecurity law has this double focus. And without any doubt, it is clear that the measures which are proposed for network security by this law, so that means the technical and organizational measures, they are quite the same that are also being proposed by the European legislators, because this is a technical situation, and this technical threat situation is nearly everywhere the same, and you need to implement some kind of management system to be compliant with the laws. It is more interesting that the data protection provisions of this Chinese cybersecurity law are somewhat quite similar to the ones that we can find in GDPR. So that means that there are the basic principles that can also be found here in this law. That means confidentiality, earmarking principle, informed consent for data use, certain regulations for privacy breaches and rights of persons concerned. But generally, compared to the European level, the Chinese data protection level is still below GDPR. And this is why, for example, binding corporate rules would apply when transferring personal data from the European Union to China. And you can see here on the left-hand side a newspaper article from a German well-known newspaper, which is called Handelsblatt. And they had this article about China's internet regulation. So it is said that German firms are hit by China's internet crackdown. And the question, of course, is what does this mean? And there have been several problems being discussed here in Europe about Chinese cybersecurity regulations. The first one was a disconnection of VPN, because many companies transmit their sensitive data with virtual private networks. And there have been several announcements of the Chinese government to shut down these VPNs and only to use state licensed VPNs. Another problem was the so-called product certification. Because there are also many German technology firms that are exporting technology to China, and the Chinese cybersecurity law also defines relatively strict security requirements for specific cybersecurity products or critical network equipment combined with Chinese test standards, and it's very difficult for German companies to be compliant with that. Of course, also due to the language barrier. And the problem of data localization. That means some kind of data which has been created or which has been generated during the operation of critical infrastructures should be stored in China. This is set by the Chinese cybersecurity law. But there's also the question if this duty to store data in China will be or might be extended to all network application and not only to critical infrastructure operators. So to come to a conclusion as well as to an outlook, we have seen that cybersecurity is a hot topic of regulations, and there are many different approaches for cybersecurity on international level during the last years. And Germany and Europe, they are both trying to address these cybersecurity issues as a uniform approach with completely new laws directly from the scratch based on their respective political strategies for cybersecurity. We can also see that when we compare the different laws in the world, that although there are different political goals for cybersecurity regulation, the technical and organizational measures which are proposed are quite similar. For example, in China, for example, in Japan or in Russia. And a big thing of regulation for the next years, which is also being addressed already by the European legislator, as well as by the Japanese legislator, is the regulation of IoT devices, which are mostly used in private companies and households, how to make these devices secure. And we have also seen that a challenge for cybersecurity regulation is a connection to the technical regulation, and this link can be created by the international standardization, because international standards can help for technical concretization of legal cybersecurity requirements. They are able to support to consistent interpretation, especially of newly announced legal provisions when there are no court judgments yet. And international standards can also be a means to conduct a transnational cybersecurity certification, which can be very useful when you have companies that are expanding their businesses worldwide, and when these companies want to be sure that their products are cybersecurity compliant in nearly every state of the world. So that was it from my side for today. Thank you very much for your attention, and I'm open to your questions. Thank you very much.
Thank you, Dennis. This is a very interesting, informative seminar and presentation. We have 3 very good questions from the participants, and then those questions are very rich and they overlap to a little bit of extent. So I tried to summarize those three questions from three different perspectives and would invite Dennis to address that. Because the first big question is about jurisdiction. On this very important topic of security, and Dennis mentions about cross-border issues. So this person would like to ask how to coordinate these cross-jurisdictional responses. And we have seen this problem on data protection, the different approaches between US and Europe, and that recently Europe has invalidated the privacy shield from US. So how shall we deal with this perennial knotty problem of jurisdiction? That is the first question. The second big question is more about how to protect different types of data. The first is about metadata. Metadata in cybersecurity or in cross-jurisdictional traffic. How to protect that? The second is in this challenging time of pandemic, of fighting COVID-19, that we touch upon medical data, genetic data, biodata, and very often we need international cooperation. So how shall we protect this type of very sensitive genetic data across different jurisdictions? And the third big question is your own opinion about the preferred approach. That would you say that we need a plurilateral approach to tackle this problem, or would you suggest that we need a self-regulatory approach? Because you mentioned that IT is moving very fast and the strategy is evolving, trying to match that. So in your opinion, that what is the best approach to deal with this very difficult problem?
So I think these are very important questions, especially the question concerning the jurisdictions. As we have seen it, national states will not be able to tackle all these cybersecurity issues, especially the small European states had many problems, and the new European states dealing with cybersecurity issues because they did not have their own authorities on that, and they even did not have some departments in federal ministries. And this is why the European legislator also said the European states will have to work together to tackle this problem, and information exchange on threat intelligence is the most important thing when it comes to cybersecurity attacks. Because, for example, in the case where the German hospital has been attacked by this ransomware, the information about the cyber attack was sent to ENISA, and ENISA was able to share the information about this cyber attack to many different other hospitals in the whole European Union. So in the European Union, we have gladly the situation where the different jurisdictions can work together by European Union law. And this is a very good approach, in my opinion, because it is not possible to solve these things, these problems, only in national jurisdictions. When it comes to international perspective, it is quite difficult, I would say. And the problem on the first hand is that many regulators have different goals when it comes to cybersecurity as well as privacy. As you mentioned already, the annulment of the privacy shield by the European Court of Justice, which is a very important topic, which is also currently being discussed by European companies on how to be compliant with the United States law, with the European Union law. And there is no clear solution to this problem so far. And I assume for this reason, to come to the other question where you mentioned self-regulation. Self-regulation can be one part of the solution, because when the governments will not be able to fully protect citizens, to fully protect authorities, or especially in this case, private entities, self-regulation is more than ever. But of course, there has to be some control for this self-regulation. And an approach would be to have a market-based control of self-regulation, which is also currently being exercised by the EU Cybersecurity Act, as well as by the Digital Services Directive, which had been published in 2019, where it is said that many products address consumers, and they should be evaluated by independent agencies or by independent companies with regards to cybersecurity issues, with regards to privacy by design, privacy by default. So when it comes to the global perspective, I would say that we have a lot of borders when it comes to national legislations. And for this reason, a self-regulating approach would be currently the best way to deal with that. But the problem is, of course, the control of this kind of self-regulation. And the last question, I think, was dealing with sensitive kind of data, such as personal health data. And this is also a problem that is being addressed by the US-American legislator when it comes to prenatal genetic testing or genetic testing in general, because there are also companies that offer genetic testing that come from third countries that are not being considered safe from a privacy perspective. And many consumers just log onto the prices of any DNA testing offers, and they do not think about these privacy issues, which have also to be addressed, because genetic data is very, very sensitive data, such as biometric data, for example. And for this reason, there should be more awareness raising when it comes to consumers that are using this kind of products. And awareness raising is a thing that can be done, definitely be done by national legislators and by national provisions for consumer protection, for example, in the civil law.
But in the COVID-19 fight now, is the government who is collecting our health data, then would your analysis be the same?
Yeah, of course, this is an exception that we currently have. And even though in Germany and in the European Union, there are high privacy and data protection standards, we had several cases of misuse of COVID-19 data that had been collected by health agencies, and this kind of data has been used in non-compliance with the earmarking principle of the GDPR by police authorities for criminal investigations. And this is something that is, of course, illegal. And there are also discussions about the Corona fighting app, which has been updated, I think, yesterday in Germany. And of course, the data which is collected by the app is here in Germany anonymous, and I think in many other of the European states as well. But there's a high interest of state actors currently to collect more health data than ever. And we have to be aware as citizens of the situation that when there are surveillance measures created by the states, new surveillance laws, and should it only be for fighting the pandemic, there might be an interest of state authorities not to end these data collection and using practices of personal data when the COVID-19 pandemic has ended. So we should always be aware of that.
And we have two more questions. The first one is how to incentivize multinational financial institutions to take stronger measures to protect the client's privacy. And the last one for today is about the standard of proportionality that you have mentioned. That is, the question is in regard to EU NIS Directive Recital 53. That is mentioned about the standard of proportionality. So is there a standardized measure of proportionality that is being followed, and has there been any legal precedent on this matter? So
yeah.
Dennis, can you address these two issues?
Yeah, of course. So the last question, I will start with the last question. So there have no court judgments or anything like that before. So it is very difficult to have a clear interpretation of this Recital 53. And this is why there's a lot of legal uncertainty. So we will not find any kind of blueprint for this weighing of interest, and this makes it also so difficult to address these cybersecurity issues here for company. Possibly this might be changing, but the NIS directive came into force in 2016, and the member states had 2 years' time to implement it in their national legislation. So that means this law is really in force only since 2 years. So there are no court judgments. So this is also one border, in my opinion, of legal regulations that we face here, and this results in a high legal uncertainty of providers of critical infrastructures as well. Yeah, and the first question, can you repeat it, please?
How to incentivize multinational financial institutions to take stronger measures to protect their clients' privacy?
Yeah, so this is also a good question. Client data is, of course, a question of data security as well as privacy issues. And when it comes to privacy issues, we think about GDPR. And it is interesting because when we had the old data protection directive as of 1995 from the European Union, the administrative sanctions for non-compliance with privacy rules in the European Union was quite low. And with GDPR, it has changed. So it is set that the maximum fine for non-compliance with GDPR could be 4% of the total annual turnover of a company, or a maximum value of 20 million euros. And the result was that many foreign companies, not only the banking sector or the financial sector, many foreign companies, technology companies, telecommunication companies, were looking at the European Union, because even though we have the Brexit, the European Union is still the biggest digital, or in general, the biggest interior market in the whole world. So there is a lot of economic power in it. And this is why the market is interesting for many foreign companies, but they see when they want to compliant, or when they want to have market access, they have to be compliant with the European data protection law. And the European data protection law prescribes relatively strict measures, for example, market location principle. And when these companies want to access the market, they have to take all these privacy and data security measures for the products and services into account. So in my opinion, to answer this question, a way to regulate foreign companies in the own native market is to put high administrative sanctions into force. This is best way, in my opinion.
Thank you so much, Dennis. If we are attending the live presentation, I would invite all of us to give a big hand to Dennis. And it's Friday, and so thank you for joining us. I wish you to have a very nice weekend, and keep well and stay safe. Thank you.
Thank you very much. Goodbye.